can hear me with this new interesting AV setup. Representative Krajewski, Chair of the Commission, gonna bring this policy meeting into order. First, want to recognize the members who are in attendance. In person, we have myself, as well as District Attorney Nathan Bible, Judge Daly. We have Chairman Fox, and then we also have here for the DOC Secretary, Executive Director Wienerowicz. All right. From one Eastern European name to another, I want to make sure I got that correctly. And then I believe virtually we are joined by Professor Rago and Judge McDermott and Attorney Balkovic. Is there anyone that I have missed?
Representative Bonner, it looks like.
Oh, okay. Representative Bonner has joined us online as well. Okay, so with that, I do believe we have a quorum. And I believe next order of business would be approving
To the policy meetings.
Okay, great. We're right into it.
All right, thank you, Chairman. And good morning, everyone. It's really nice to have our meeting here in State College. We had a wonderful dinner with some of the members last night. And today's policy meeting, as you know, we changed our format where we're not hosting policy meetings at every meeting. But this seemed an appropriate time given the volume of work and some of the changing circumstances where we need input on policies related to the work of the commission. As we know, for the last year or so, we've been working heavily on developing this next gen application called CASER. And as in our development of that, there's been a number of areas where we need feedback, starting with the guideline sentencing form. And Ryan and Christy will go through some of the work they've been doing on redesigning that form, the outreach effort they've had with judges and other key stakeholders across the Commonwealth in reviewing that. And as that programming, developing that application's been going on, it became clear to us that there needed to be some decisions and policy discussions surrounding the definitions of conformity. With the new guidelines, the tighter ranges, the different levels, it brought up some areas where we just need clarification. There's two types of conformity here now with the new guidelines, durational and dispositional departures. So it's a little more complicated. And again, we could use some guidance on that. Ryan then is going to lead a discussion talking about omnibus sentencing enhancements, building on some of the material he presented at the last commission meeting. And then the final three modules of this policy meeting are to showcase and share with you some of the work from the Research and Data Analysis Unit. We've been working, as you know, on this study of veterans involved in the criminal justice system for the last 15 months, and we just submitted that final report to the Senate. And so we'll just highlight to you some of the recommendations and the processes surrounding that. The team has also been working on another evaluation of short sentence parole, and the earlier evaluations we've done didn't have a lengthy tracking period for recidivism. This update is extending that period as more people have entered that program, and we're able to look at them farther out as it relates to recidivism. And finally, we have a mandate to validate the sentencing risk instrument. Just briefly, the idea of validation is, and the team will go into great detail about this, is that tool was developed with really old data, 2004, 5, and 6. So we need to just make sure it's still working the way it was designed. So we're not redesigning the tool, we're just confirming or validating that it's working in the way that it's intended. So that will have a whole bunch of statistical mumbo jumbo surrounding it, but hopefully everyone will see when we finish that it's not pro forma, but again, we're not digging into the weights of individual factors and opening up that can of worms. We're just saying, does it still work the way it was intended to work? So with that, I'll turn it over to Ryan and Christy on the first piece related to this, the guideline sentencing form.
We'll just note that Judge Marsico has joined us in person as well. So thank you. Okay, as Matt had mentioned, the goal here, at least in the morning, which I'll lead and Christy will assist on, which when I say assist, Christy will remind me of what I forget to say and correct me for the things that I say wrong. But the three parts, as Matt mentioned, again, we'll talk about the guideline form. We'll talk about conformity and we'll talk about the omnibus enhancement. And this is really one of the first times we've had now since the implementation of the 8th edition to dig into some of the details. And I think it's a nice opportunity from a staff perspective to bring to you some of the lessons that we've learned and help guide us moving forward. As we all appreciate, there was a lot of changes with the 8th edition. And it took a while for cases to come into the system. And so we were, diligent in monitoring that, but also recognizing that we needed to allow enough time for cases to come through the system to start to inform some of the decisions we were making. So we'll start here with the guideline sentence form, and then I'll get into the conformity and omnibus enhancement. I think the best place for us to start is to show you what the current SGS Web form is. So the SGS Web is our current application, and it's been our legacy application since the early 2000s. And one of the things that we've long heard about the guideline form, whether it was the 7th edition or it's the current 8th edition form, is it's busy, right? And so the point of this slide is to say, this is what we currently have, and it's not optimal, but it is what we are able to do currently in SGS Web. And so the goal that I would at least want to mention from the start here is to say, we really want to just clean the form up. We want to simplify the form. We want to streamline the form for practitioners so that, when you're looking at it in a busy courtroom or on the bench, that you're able to glean the information that's most important to you, and that it just overall makes more sense. And unfortunately, this form is not doing the job that we want it to do. So we're thinking about the future application and being able to make those changes. And this is just a side-by-side comparison to show you that at least at a high level, I think we're achieving some of that already in terms of the cleanliness of the form and that streamlining. And what we'll do is we'll walk through here and highlight the various areas. It's not only that it just, I think, looks better, but it's organized in a way that makes more sense. And before I get too deep into this, I put a note here and then I forgot to look at it. On the top of my page was to thank the members that met with us for some meetings to give us some feedback. And we also met with, as Matt mentioned, some other stakeholders outside of the commission to get some feedback. And I just wanted to mention, I sat in, I think, on all of those meetings with Christy, and it was just extremely valuable information that was provided to us. And the big takeaway I would say is the general feedback was that it was positive, right? That the members and others felt that the form looked good and was doing the things that we were trying to achieve. But as with anything, this is sort of the first iteration of the form, and there's opportunities for improvement. And so we will talk about the feedback as we go through. We'll try to weave it into the review of the guidelines. So in terms of the organization of the form, as you see on the left-hand side, we have the what we call the offender information, and that's dictated by the application. And this is where we try to compile what was sort of disparate across the form into a single area. So if you're looking at a person coming through the system, certainly you'll see demographic information, but you'll see all sorts of programming eligibility. And as an aside, the commission has a responsibility through its enabling legislation and also through statutes to identify eligibility or ineligibility for individuals for certain programs. So we wanted to kind of get this offender level information off to the left, because to some degree, it's a little static, right? In terms of it's focused in on that person and or their conviction offense. So that's on the side, and we'll go through some of this stuff in greater detail. One of the areas that we received feedback, actually, I'll say it in another part of the slide. So I'm looking at my notes. So this is why Christy's sitting next to me. Stay organized. So the next area, just in terms of organization, is the offense information. And if you think back to 2 slides ago in the original form or the current form that we have, each form represents one offense. So all of that information you see on that form is for one offense. And we're unable to put multiple offenses onto a form. With the reorganization of it, at least as of now, it looks like we can put 2 offenses on a form. I mean, that's pretty impressive, right? We went from 1 to 2. So if you had 2 pieces of paper, now you have 1 piece of paper. But I think that's helpful and it's cleaner for what you can see here. And then the other area that we wanted to focus in on was making the sentence recommendation, right? That's sort of the bread and butter of the commission, a big responsibility in promulgating guidelines and providing recommendations to the court and to the parties to make that clear and stand out, right? And I won't keep comparing and contrasting, but I guess if you look at the current form, it's oftentimes lost in that form. And that might be the thing you're looking for primarily is what is the sentence recommendation in this case? And, you know, we send you on like a Where's Waldo chase for it. So here we think that the way in which it's organized stands out much more for individuals moving forward. What we'll do is we'll walk through a couple of different scenarios for the sort of offender level information. And here's where you'll see the demographic information at the top, and then some of the responsibilities of the commission. You know, we have our sentence risk assessment, which will be generated for each conviction offense. And so we'll have that sort of at the top where you see risk assessment. I think that's more prominent and something certainly the commission worked on for a long time. Then you'll see the offender eligibility, and we can talk a little bit more in detail about this. But at a basic level, these are those programs like county intermediate punishment, now known as restrictive conditions of probation. We've got the motivational boot camp, state drug treatment program, triple RI, short sentence parole. And these are all areas in which the commission has historically provided some level of eligibility information. One of the things that I'll note here is, it might be hard to see on the screen, but under the label of offender eligibility, we put a note to say that it's based solely on the offenses in this judicial proceeding. And that's something, at least from an education and outreach standpoint, we try to make individuals aware that the commission can only provide information based on the information we have. And so when you look at a lot of the eligibility statutes, you have clear offenses that if a person has a current conviction for them, they are ineligible for that program. We know that by the information that's entered into SGS Web. But there's, the phrase within statute that says, well, maybe if they've had a history of present or past violent behavior, they would be ineligible. We don't know that, right? That's a decision that's being made by the court at the time of sentencing. It's subjective to the court. It's not dictated by crimes of violence in statute. It's, whether the court thinks that person has a history of past violent behavior. And so one of the areas in which we received some feedback was, is there a way to make that clearer to individuals? And so we're going to think about that. And that might be an education and outreach thing. It might be something that we can add to the form. But that's something we need to make sure we're being clear that when a court's looking at it or practitioners are looking at it, it's not to say if we say a person's eligible that there might be other factors that render that person ineligible. And so one of the things that we received was, is there an opportunity to put, help me out here, is there an opportunity to put a box there that would say this person, let me give this example. If the commission says it's eligible, but the court determines they're ineligible for other factors, that we could insert a box that would allow the court to check, yeah, this person's ineligible based on other factors beyond, say, the conviction offense. And so I think that would be, a helpful development to the form, at least in being clearer what we're saying. So that was one area. Another area that we received feedback on is to add whether or not a person's eligible or ineligible, that's made eligible or made not ineligible for county reentry. And that's something we don't currently have on the form. And anytime the court is sentencing somebody to county confinement, they're required to state whether or not that person's reentry eligible. It's not an action that the commission would be making in terms of dictating or insinuating to say this person would be eligible or ineligible. It's just a decision that the court has to make. And I think for most of the practitioners and judges in the room, you remember when it was really sort of, you only ever said it when they were, and the court system was quiet when it wasn't. But there was an appellate decision within the last few years that said the courts have to state it in either direction. So I think having something on the form to allow courts to capture their decision during sentencing for county reentry will be helpful. So we would see that under this offender eligibility space. The next thing that I'll mention, and I guess I'm not following down through my boxes, is, and I want to use this slide to say, one of the things that we envision being really helpful and what will be great about a new application is its ability to be more fluid and represent information that's relevant to that case. And here I'm already saying, I'm not going to keep comparing and contrasting, but the form we currently has every possible option that could be in front of the court. And you might have a person coming through the court for a non-sex offense, but on the guideline form, we're populating information that says, box for the tier of a sex offense or the tier of the offender, and it's just not applicable to the case. And so sometimes we'll receive, inquiries about like, why is this on the form? And it's like, well, everything's on the form. But in the new edition or the new application, we'll be able to be more fluid and flexible in which we populate information relevant to those conviction offenses. And so what you see here is that in the previous example, maybe they didn't have a DUI. So we're not showing you all the requirements around DUI evaluations. Now, in this example, the second column, we could say this person has a DUI conviction. So now we populate on the form any assessments that are related to DUI statutes. So we think that'll be helpful and also allows for the forms to be keeping that cleaner look and not, putting too much on the form at one time. And then here's an example in which now you have a person who has a sex offense, and then we can populate the Megan's Law requirements for that. And so that's just something to keep in mind as we go through or we build out to this new application, that the system itself is going to be able to be sort of like moving with what a user is doing inside the system. And we won't have those instances in which we're populating everything when it doesn't need to be there. So we'll talk a little bit now about the offense level information that we have on the form. And again, I think we found that this is working well, at least in the initial feedback that we received. Well, at the top of the screen, it's pretty straightforward. We have the docket level, OTN information, and also the count. So that's really easy for an individual to look at. When you move down the form, you'll have that offense level information, what the conviction offense is. This is all the sort of statutory information. This is not guideline related. This is the grade of the offense. We'll have what the date of the offense is. In the instance, we'll have like the age of the individual at the time of the offense. And then consistent with past practices, we've always indicated to the courts what the statutory maximum would be for the offense. And so what you see on the screen here is, I guess, our first attempt at communicating that, which we found pretty consistently, it was not a really good attempt. So one of the things that we received in terms of feedback was the use of the term statutory minimum was maybe not so clear, and could get misconstrued to be that with mandatory minimum. And so again, these aren't recommendations. This is just what I always talk about as the outer limits or the limits established by law, right? So if it's a felony 10 to 20 years, not a recommendation, but just saying, these are your guardrails. Don't do 11 to 21 years. So what we looked at in terms of what are some opportunities here? What are we trying to communicate? What we have thought of, at least internally, and talked a little bit about with some of the judges and others, was the use of the term maximum penalty. All right. And I think that's where we're going to go next, which is to say, sort of in this row, that here's the maximum penalty, here's what the minimum would be and the maximum would be, because that's essentially what we're trying to say. Under the guidelines, we do make use of a term statutory limit, and that was on the old form. And it's a term that we define in the text of the guidelines, which we say is the longest allowable minimum. But we kind of wanted to separate this out. This is not guideline related. This is statutory references. And so if we're using the term statutory limit in the guidelines, we want to sort of retain that there. So we're hopeful that at least that maximum penalty kind of communicates what we're saying. And I think that will do that for individuals. Here will be the OGS and the prior record score related to that offense. And I'll talk a little bit here about prior record score. And then in a future slide, I'll talk some about the offense gravity score. But this would be the OGS assigned to that offense. And then, of course, this is where we would be populating for the courts to see what the prior record score is. And in this, you'll see that we say that there's 2 prior convictions or adjudications in a prior offense group 1. That's how they ended up in the prior record score 1. Some feedback we have received is there are opportunities for us in this new application to communicate maybe some additional information. Like what were those 2 prior convictions? And I'll have to say, just full transparency, I don't know how much we'll be able to do there. There's going to be some limitations. Christy and her team are building out a wonderful application. And I believe that they can do just about anything, but there is some limitations in what we can provide. And it's really going to be dictated based on the information that we receive either through AOPC or if a person is entering manually prior convictions. And so there's just some nuanced complications in terms of the programming and the application. But what we can look at in terms of a staff perspective is there a better way to communicate this information and make it clearer? So we'll look at that, but that's some feedback we've received. I think this is at least a good starting point. You do understand at least that there's some convictions coming out of a certain prior offense group rather than leaving it just as prior record score 1, right? And then in any instance in which there's a victim in the case, we'll populate the age here. We collect that information for certain offenses. If it's not relevant to the conviction offense, then you won't see that information. So again, I think this will be a learning in the future for us that are used to things always being on a form. But if it's not there, it's not necessary. And if it is there, it will be necessary for you to look at. Also in this space, we will populate in whether or not there's mandatory minimums associated with that offense. Here, I think we're using an example of DUI. And so, we do a similar thing under the current guideline form, but we want to retain that in with that offense specific information. And then if there's an enhancement applied, you'll see that enhancement applied right there. Right? And again, these won't show every time. Right? If a deadly weapon's used and it's selected in the system, it'll populate on the guideline form. If it's not selected in the system, it won't be there. And this, it could be multiple enhancements at one time. So you would see, multiple enhancements here. One of the areas, let me just look real quick. It's a good spot to talk about it. All right. One of the areas we received feedback in terms of the enhancement was, is it possible for us to include in what I'll call the description of the enhancement, how it operates, right? For the deadly weapon, we increase the OGS by some number, whether it's +2 or +3. I think in this instance, it would be +3. And so we don't mention that here. And so I think that's an area in which, we're not communicating enough information to the courts. And many of the individuals we met with felt that would be helpful. Like, how did you get to the end OGS? In this instance, the OGS is 19. The system has internally done it. I was jokingly saying it's like when you're doing your math problems, my daughter's 10, and it's like, show your work, right? Here's the answer, but the question is, how did we get to 19? So we think if we put in the description of deadly weapon in parentheses at the end, that it would be +3 OGS, then at least you would know if that enhancement weren't to apply, you could adjust down what the final OGS would be. The OGS that you see below is the final OGS. And what we're talking about was, well, if there's an enhancement that changed what the base OGS was, or the original or initial OGS, that maybe next to OGS 19 in brackets or parentheses, we could actually put what the initial OGS for that offense was. And so we can look into that and see if that's helpful. We certainly don't want to make things confusing, but again, that's sort of showing the work and how we got to that final OGS. And I think from what we understood from feedback from individuals was, yeah, it really would be helpful, particularly if the court found at sentencing that, that factor didn't exist, right? Or there wasn't enough, not preponderance of the evidence to apply the enhancement. Then at least on the fly in the courtroom, the prosecution and the defense could make that adjustment in what the OGS was. Now we move down to the sentence recommendation. Again, was called out here by Gray, so you could see it really quickly. I think I mean, for the most part, I feel like everybody in the meeting that we were in felt like this was good. They could see it clearly and it's communicating the information we intended it to. One of the things that Christy and her team did in developing it was instead of just having level E, we're saying what level E is, so you know that's a state confinement one, sort of orienting you to the levels of the guidelines in case you don't have the matrix with you or your guideline, text. One thing that we did receive, and I'm not sure we're gonna go in this direction, but I at least wanted to put it out, it was feedback. Is there an opportunity to provide what the actual range of the mitigated and aggravated would be? That's not something we've historically done, which doesn't mean we can't do it moving forward. But it does add more numbers to the guideline form, and we can look at that and run through to see if it actually communicates what we want it to or if it looks nice. But that was something for some people. Like, is this intuitive to an individual looking at that the mitigated range is 21 to less than 30 months? And the aggravated range is, greater than 42 months up to 51 months. And some of these things, we might be able to accomplish by adding text to the form, or we could accomplish that through the use of the education outreach unit as we train on the new forms. But I at least wanted to say that because we did hear about it during our meetings. Let's see. All right, so before I wrap up, I'll pause for a second. I have two more comments to at least make in terms of some feedback that we received, but I know we met with most of the members that are here, so I don't expect that you have any additional, but I'll pause for a second before I wrap up. Silence reigns supreme. I like it. All right. So
You really just need some coffee.
yeah, just some caffeine to get through conformity in a minute. So just for the slide purposes, because I'm going to click past these, this is in case I forgot to say the information. We thought it would be better to give you the visual and the feedback at the same time. So this is just summarizing the offender eligibility that we talked about, the offense specific information in terms of the statutory maximum or minimum, replacing that with a maximum penalty. This, we talked about the OGS in terms of adding +3 or +2 in that example behind deadly weapon, and the initial OGS as well. The final thing I wanted to say, and this is best on this slide because we didn't really have a good example necessarily to talk about it, but one area, and this is broader than the guideline form, one area we've received, and I know Bobby and his unit and their trainings have had to deal with this. If you look at just our basic sentencing matrix, and in particular at level C, we make a recommendation of county confinement, for example, 1 to 4 months. And then next to that in parentheses, we have RC. And what we have found over implementation and working with counties is that that's just not clear what the commission is recommending at that level. I mean, it's clearer if you read the text and then you look at the matrix, but we appreciate that you might not be always reading the text. I mean, we would love you to read the text, but it might not always be the case in the courtroom at that time. And so it's just an opportunity for us to think holistically about this, both in terms of the new application and a guideline form, but also just how do we better communicate what the commission's recommending. And in that level C in particularly, the starting point's county confinement. The RC is an indication that the court, if they so choose and the person's eligible and appropriate, can make use of probation with restrictive conditions in lieu of county confinement. That's what it's intended to communicate, trying to communicate a lot in a tiny little cell. And so that's an area in which I think as we move forward, we will revisit that, see if at least if anything on the guideline form, we can provide better context or definition around that. And then in the future, the commission, we can look at just the 8th edition as a whole and the matrix and so forth. So that's an area that we'll focus in on moving forward. And then the last part. Yeah.
So Ryan, when you guys say restrictive conditions, do you mean electronic monitoring, or is that what your intent, is that the intent? Okay.
So it would, that's one of them, right?
Okay.
So if we looked at the statute for probation with restrictive conditions, there's a number of different restrictive conditions. Most common in all counties is in-home coupled with electronic surveillance. Yeah.
Always go right to.
Yeah.
This.
But there's, and I mean, we could have a whole session on restrictive conditions. There are other ones though, right? But that is the most common. And inpatient treatment could be one as an example. Even partial confinement for a limited period of time. You can make use of partial confinement as a restrictive condition of a probation sentence. And so depending on certain counties, we'll make use of that more. Other counties, it's, by and large, electronic monitoring.
So would you consider incarceration with work release to be?
That'd be partial confinement.
Okay.
Yeah, and you could let's say you sentence somebody to 5 years of probation. And the court places them on 5 years of probation, and then as a restrictive condition of that 5 years, they say 30 days of partial confinement eligible for work release.
Okay.
Yeah, so that'd be how you do it, under an order of probation, and that would be this kind of restrictive conditions. And in level C, that's really where the commission is intending those things to happen, for those eligible and appropriate individuals. Yeah.
Great, thank you.
The final thing that I wanted to mention is just in terms of general information that's occurring in a sentencing hearing, and maybe it'll be helpful if I just back up for a second. Let me go back. Sorry for all the clicking. We'll just use this. We have some space on the form if you're looking at the offense level information. One of the areas that we removed completely from the form is all of that sentencing level or outcome information at the bottom of the guideline form, right? And that's just a lot of what we've heard over time is courts aren't using that as it was intended 20 years ago, where it was a checkoff form and, it's used differently. And so by removing all of that, it gave us a lot of space and reorganizing. But one of the things that we appreciated in our meeting was that there could be some utility to some area on the form for the judge to write some information, things like, here, I'll just make you nauseous for a second. Walk back through this. For information like credit for time served for that count, right? It's just having a space for the court to notate as they're working through their order of sentence. Count 1, yeah, there's 30 days of credit on this. If there's multiple counts on a docket, count 2, you could scribble consecutive to count 1, right? Just some of that basic information. Also, if there's reasons for your sentence, right? If you're departing from the guidelines, or if you're now under the 8th edition, you're sentencing in the aggravated or mitigated range, it could be helpful for the court to just notate their reason there. So that's an area in which we think we can provide sort of like a blank text box. And the purpose would be when you physically have a paper form in front of you, you could jot some notes in that. And that'll vary by county in terms of the utility of that. But we have 67 counties and we want to make sure we're doing our best to try to provide useful information. And I think we can accommodate that pretty well. So, all right. A lot on guideline forms. If there's no questions and no questions coming from our members online, I'll continue on to conformity. Okay. So I'm going to, in the first few slides, I'm going to walk through what staff have done since the adoption of the 8th edition guidelines and when the guidelines became effective. I think I mentioned earlier, there was an effort initially just to prop up SGS Web to be able to generate a guideline form come January 1, 2020, right? And that was really the goal. And Christy and her team did an amazing job in getting us to that point, because we just had to be able to have guideline forms generated in early 2024. And when we did that initial deployment, what we did at the time was we retained all of the conformity labels that we had existing in SGS Web for 8th edition moving forward. And what that means is that in the past, we always reported out in terms of a departure above or a departure below, right? If the court was sentencing outside of the ranges of the guidelines. So in terms of conformity, if the court sentences to a standard range, mitigated or aggravated range, the commission, we view that as conformity to the guidelines, right? It's within the ranges. And if they were outside of those, we would just simply say outside, above, or below. And we did that purposely moving forward. We needed to see how the eighth edition worked, and we also just, in a timely manner, needed to have the ability to provide information to the court. So we monitored implementation since the effective date of the eighth edition, and since we deployed that update in SGS Web in January of 2024. Over time, and this is a big part of the education and outreach unit's role within the agency staff, is they're sort of the front line of dealing with courts and practitioners and receiving information. And so they monitored the implementation of the guidelines, and then working closely with Christy and her unit, reviewed the programming of SGS Web. And over time, and I think we expected this, we weren't naive to it, but over time, we really understood that we needed to make some changes in SGS Web to better reflect conformity under the eighth edition guidelines. It was fine what we did in the beginning, but now that we're seeing these cases come through, we should really be consistent with the text of the guidelines and what the commission ultimately adopted in the eighth edition. And so that's required us internally to change things in SGS Web. And so we are going to talk about those conformity labels in a moment and what we did in terms of changing it. But, why did we have to change it? Just a little overview and a reminder to say the eighth edition shifted the recommendations of what we made to courts, certainly through the lens of conformity. Previously under the seventh edition, the ranges were pretty wide, and in most instances, the courts could go from guilt without further penalty to state prison within a range, right? Either from mitigated up to aggravated. And so it was, when we looked at conformity previously, we were pretty hyper focused on what the minimum term of confinement was relative to the standard range or to the mitigated and aggravated range. And that's how we reported. So if the court was above the aggravated range, it was outside above. Or if they were below it, it was outside below. It just didn't work and wouldn't work under the eighth edition, because when the commission adopted the eighth edition, there was this duality of conformity, right? There was an intent to say when the commission says county confinement, they mean county confinement, right? When the commission says probation, they mean probation. There was much more of an effort to say, here's the sentencing alternative. Then in addition to the sentencing alternative, the commission's also recommending duration. So now we have a disposition we're looking at, and we have the duration that we're looking at. Before, it was really just mostly about the duration of a sentence. And so we had to think about, how do you communicate that to a judge as we collect information? And, we received calls from courts where we were saying before these changes that it was a standard range sentence when it was recommended that it be a county jail sentence, yet they sentenced them to state prison. And that's not what I think the commission is saying, right? The commission is saying it's a county jail sentence. But the reason it was a standard range sentence was because they kept their minimum in the standard range. And so we just had to accommodate, to be able to say to a court, like, look, you can do that. You have the discretion to do that. Put your reasons on the record. Right? But if the commission's saying county confinement and you sentence somebody to state prison, regardless of what the duration of your minimum term is, we should be noting that that's a departure dispositionally from the commission's recommendation. That's sort of a starting point. And then we can also look at duration. So as we worked through this, we updated the labels for the eighth edition to remove just outside above and outside below, because it just didn't communicate what we needed to. And so we added to SGS Web two types of departures, in effect, dispositional departures and durational departures. And we retained all the standard language of mitigated, aggravated, and did I say mitigated, standard, aggravated? And then also one in which there's a procedural departure. If the court just didn't follow the guidelines, didn't look at the guidelines, didn't have assessments for drug and alcohol or for DUIs and other things. But we changed that above and below to have dispositional departure. either above or below, or durational departure above or below. So now we have sort of 4 labels that we're using in communicating information to the courts and also to the practitioners. And that release and that update happened in August. And coupled with that, Bobby and the Education Outreach Unit communicated information to users to let them know they'll be seeing some changes. And we have information available in terms of resources on our website because it will be something new for individuals. One of the things I wanted to mention here, which, you know, there's some complexity to this. It's just not, is it outside, above, or below anymore? And so in deciding how to communicate conformity to the courts, we all had to create a hierarchy of decision-making within the application. And what we'll go through in the next, several slides is some examples by level, just so we can appreciate a little bit of what we're trying to achieve in the new application or in the current application. So what we decided was we'd focus first on what the sentencing level's sentencing alternative was. That would be sort of the primary decision in the hierarchy. So that if that example I gave you before, where if the commission's recommending county confinement and the court sentences a person to state confinement, we're going to flag that as a dispositional departure above, right? So that we're saying, hey, this was supposed to be county confinement and you sentence them to state prison and they'll get a notice about that. And they provide a reason for why they did what they did. Now, if the court kept it in the standard range sentence, you could see how we don't want to tell them that it's a standard range sentence and you conformed durationally, and then also tell them that you've departed dispositionally. Right? It's just you're sending sort of mixed messages. So what we have done, and I think this makes sense, and certainly we'll hear from counties if it doesn't, but we'll start at that higher level. What's the alternative? And if you're departing from that, we'll start there. And then if the court decided, okay, well, I'm going to change it from state prison to county, then we'll look at the duration and we'll let them know if they're conforming to the duration for that recommendation. And they could be departing in both instances, both from a dispositional and a duration standpoint, but we're only going to show the disposition to start. So I know I said disposition and duration a lot there and departure, but that's sort of at least the big view of what we're trying to achieve here. So maybe to make this a little bit more clear or visual, I wanted to walk through several levels here. So just like hang in there, we'll get through these kind of quickly, but there are examples. So if we look at level A and look at OGS 3, prior record score of 0, these would be our guideline ranges, right? Mitigated range, standard range, aggravated range. And so when we're at this level, the floor is restorative sanctions, which is what RS stands for. So you simply just can't mitigate below the floor, right? That includes guilt without further penalty, fine, what we term as administrative probation, right? So the standard range would be sort of any of those things to include administrative probation up to 6 months. And then the court can aggravate from that and place a person on general probation supervision for up to 3 months. And that's sort of the range in which you'd live in terms of conforming to the guidelines. So how do you depart in these instances? Again, if we have the floor built into the range, there's no departures below it. So you wouldn't have a dispositional departure below, you wouldn't have a durational departure below. But you could see in courts departing above. And so an example of a dispositional departure above, if the court sentenced somebody to county confinement, right? That's it. The commission's recommending restorative sanctions, courts placing them in county confinement. There's your dispositional departure above. From a durational departure standpoint, where the aggravated range went up to include 3 months of probation, if the court placed somebody on 4 months of probation, and that was the sentence, they would be receiving this flag in the system that it's a departure above in terms of the duration of it. And so, this is the information that we would be providing. Level B, this is probably one of the more there's a lot of moving parts in terms of level B, but the commission fundamentally is recommending probation as an alternative. Mitigated range for this cell of OGS 4 and prior record score of 0 would be down to RS, restorative sanctions. Or it could include a sentence of general probation up to but less than 6 months. So there's space in which the court can work there. Standard range is 6 months. This is, a single number, obviously with probation, unlike confinement sentences. Aggravated, it would be general probation that's greater than 6 months, up to 12 months. That sets the conformity for that cell for the court. And then these are instances in which if a sentence was ordered, we would see in our system where there would be departures. Again, no departures below because RS is included in that range. But if the court sentenced to confinement, makes sense, a dispositional departure there. And then if the court sentenced above the aggravated range in terms of what the highest level for probation would be, which was 12, and they sentenced to 13 months, that would be one of those ones where we'd say this is a durational departure above. We thought it'd be helpful to just talk a little bit about an example in level B that goes beyond simply general probation. So if we move across the matrix to the right, OGS 4 prior record score of 2, this is where the commission in its recommendations built in restrictive conditions of probation into the standard range of it. And just as a reminder, the commission, you were, as part of Act 115, we were directed to look at not just the duration of probation, but also the intensity of it as well. So in the standard range, the commission's saying in the mitigated range, the commission's saying 12 to less than 18 months probation. You could have no restrictive conditions here, or you could have up to less than 1 month of restrictive conditions. For the standard range, probation with restrictive conditions, 18 months, 1 to 2 months of restrictive conditions. Then we have aggravated, which would be greater than 18 months to 24 months, and that's including 1 to 2 months of restrictive conditions. So there's a lot of moving parts here. It's probably one of the more complicated levels that we have to deal with in representing what are departures from this. You can see a dispositional departure below if the court were to sentence somebody to, say, administrative probation, or if they did guilt without further penalty, because that's falling outside of the mitigated range. If the court, again, it's, I think, pretty straightforward. If they're doing confinement, it's a dispositional departure above. We get into durational departures. So if the court just said, I'm just going to place you on 6 months of probation here, it's a durational departure below. It's outside of the range of the guidelines. You're not seeing any restrictive conditions and so forth, but more importantly, just from a duration standpoint, it's below what the mitigated is. And even if the court decided to keep the person on probation, but they sentence them to a lengthier term of probation beyond the aggravated range, that's where we would see this durational departure above. So it's not, they haven't gone outside of what the level is recommended in terms of probation, but the court's gone beyond what the commission has built into the range of guidelines. All right, hang in there with me. Only 2 more levels to go. Level C, this is where we move into the county confinement. And as we discussed earlier, the possibility of the use of probation with restrictive conditions in lieu of it, but we'll just focus in on the confinement for now. Here you'll see the 3 ranges, 6 to less than 9 months for mitigated, 9 to less than 12 in the standard range. The reason, as a reminder, that it's less than 12 is that this would mean that if the court sentenced them to, say, 11.5 months, they doubled their minimum, that would keep the person in a county jail. Keeping in mind that if it's 2 years or greater on the maximum, that's a presumptive DOC sentence. So that's something we always talk about in this level. It's like, why is it less than 12? Well, if you did 12, you'd do 24 on the max. Starting point there is they're going to go visit the Department of Corrections and then eventually see Chairman Box. And then we go to the aggravated, you'll see this is greater than 12 months to 15 months. So yeah, we're moving up into an area in which we would presume it to be a Department of Corrections sentence, but it still remains in this county level. And counties have the opportunity to exercise an exception to keep these shorter sentences in the county. So we're retaining this viewpoint of county confinement. I'll move through this pretty quickly. So if you move if you look at the dispositional departure below and above, we have probation, that'd be below what the commission's recommending. State confinement would be above what the commission is recommending. This state confinement one's sort of the example I gave earlier, where if you look at the minimum term of confinement as 9 months, that's within the standard range of the guideline recommendation. But it's a state prison sentence. And so what a court would see is they would see you departed dispositionally here. Why'd you send them to state prison, right? The commission said keep them in account. So these are some of those like break points that we see within the system that we need to be able to account for and provide information on. And then, of course, if you're looking at duration, this is where you're looking at a county confinement sentence in which the minimum term is less than what the mitigated would be. And then in this example, you would see that the minimum term is greater than what the aggravated would be. So those durational ones are probably more consistent with how we've done things in the past. And then finally, with level D, this is where we have the presumptive sentencing alternative and recommendation by the commission is we're starting with state prison. And so in OGS 13, prior record score of 0, 12 to 18 months. Again, if the court sentenced to 12 months on a minimum, by rule, you'd have to at least be 24 months on the maximum. We see that as a presumptive state prison sentence. You can mitigate down to 6 to less than 12 months. You can aggravate to greater than 18 to 24 months. And then you start to see how we depart here as well. Anything, lower than that in terms of if the court did RS, restorative sanctions here, or if they did general probation, dispositionally departing, can't dispositionally depart above here. This is our most serious sentencing alternative in terms of total confinement. So we wouldn't be saying anything there, but you could depart below or above in terms of duration. And again, that's, pretty consistent with how we've done things in the past. All right, I'll stop there. Any questions? Yes, Judge.
Yeah, Ryan, if you have a sentence that the standard range is county up to state prison, and you impose restorative or restrictive conditions, say for the same period of what the incarceration would be, is that considered a mitigated range sentence?
So I'm going to answer generally, but I'm going to back up here. So we're talking sort of this level.
Yes.
Yeah. So if none of these ranges, in terms of the standard range, would include a sentence that would presumptively go to the DOC, but you could see where if you're aggravating, it would require that. What the text of the guideline says for both level C and actually level D, we don't see it on the matrix, but it's built into the text of the guidelines for those cases in which a person's eligible for probation that includes restrictive conditions. So if they're eligible and we would say appropriate for it, then you're okay, and we wouldn't determine that to be a departure because you're following the protocols and it is built into the guidelines as an appropriate alternative to confinement. So we can look at the text of the guidelines. I'll show you. It's obvious that we are saying, I guess it's not obvious that we're saying it here on the matrix, but that's what we're saying in terms of level C, that there's this trade-off. When we get to level D, it's not there at all, right? The RC is not built into the matrix. And that was a decision sort of in the 11th hour as we were coming to the end of the 8th edition to not have an indication of restrictive conditions in level D. But what the commission did retain, and I think is really helpful, is they retained in the text of the guidelines, language that if the person's eligible and appropriate. And why I think that was a good decision, and I appreciate the decision, is that the commission also assigned for those third-time DUIs an OGS of 13 because the mandatory minimum's a year. And we know that third-time DUIs, vast majority of those individuals, one, are eligible for probation that include restrictive DUI conditions. And that's a big population in which courts sentence them to. So it's, I think that's helpful and important, but we've got to sort of direct people to the text.
But it wouldn't be a departure.
Right, as long as you're following,
And the RC's not there.
because in the text, we got a little saving space for it
Okay.
that says it's okay. Yeah, and we will reflect that in the application. We are reflecting that in the application. Yeah, well, actually in the current one, in the current SGS web, but that's if they're eligible. And if they're not eligible, that's a whole nother discussion.
And then when Act 44 comes into play, now probation with restricted conditions, now that they're getting terminated early.
Potentially, sure, yeah. Assuming everything's gone well and I don't know. We'll have to have a discussion on that. I don't know how it works for mandatories with DUIs. Does it say like regardless of notwithstanding the mandatory that they could be terminated early?
I've had several of them.
Yeah. I think that's right, yeah. Again, I always think of Act 44 that it's not presumed that they'll be terminated early unless they're doing the things that they need to be doing.
But they've done the mandatory minimum.
But they've done the mandatory, which would be
It's not a
part of it.
mandatory maximum.
Yeah. So,
So Ryan, it's just so I understand, so now the judges, one of the big changes for the judges is this dispositional minimum listing reasons. If they're, at which they are dispositional departure listing reasons, because they've never had to do that before.
and part of that was just the nature of the range of the guidelines. If you look at level 3, and even to some degree, level 4, I'd focus on prior record score of 0. You could mitigate down pretty much to RS in most of those instances. So in the past, the court didn't have to give reasons for aggravated or mitigated sentences. And the fact that in the range of the guidelines, the recommendation was everything in the sentencing alternative statute. It never really was a question for us to have to deal with. Now, there were instances, as you moved up into truly state prison, longer ones, if the court did probation, it would just simply be departure below. But yeah, this is a big, it was one of the biggest changes, and that was an intent of the commission at the time of adopting the 8th edition to say more on the alternatives. And certainly then we know in terms of confinement, and the tightening of ranges and all of these other aspects. But you're absolutely right, Joe.
Are we tracking the numbers so far? Because I can imagine there's going to be a huge increase with the narrower ranges and where probation is, terms of probation are recommended, which has never been.
Right.
I mean, that's going to, I did that 10 times on Monday.
We're tracking yours for sure. That's for sure. Well, what I would say is, and Matt can add to if you'd like, but I think there was some anticipation that we would see that. But I also remind in any discussion around guidelines that it's just a good reminder that it's the starting point. They're advisory, and courts have in their discretion to sentence as they see fit. And the idea that departing is a negative thing is something that I try to dispel. There's certainly a lot of factors that aren't built into the guidelines, that we can't build into the guidelines, that you would know at sentencing. And so just by, I shouldn't say just, you need to put a reason on the record for it, and there's no problem, right? And if it's a reasonable reason, the appellate courts, I think, have shown that they defer a lot of discretion to the trial court and knowing what's best in terms of a sentence. And so I don't see departures in that negative way. I'm not saying you do either, Judge, but we do, I think, anticipate in some of these areas seeing more of them.
You're going to see a lot, but I think the good thing is it will focus us back on, because like you said, the second wide ranges
It was never really.
before where you could go from RS to state prison. So you never really had to think about the guidelines all that much. I think now it's going to focus us on, what it is and realize, okay, I am outside of that, whereas, previously I didn't have to worry about it. So I think that's the good thing from it. Again, if nobody's complaining on either side, though, it really doesn't matter.
One aspect, and certainly we will be collecting the data, and that's why this is for programming, and then obviously what the judge receives. But then when we receive the data back to the commission, one of the things that Brad Miller and I have been talking about for years was, could we look at some offenses and say, these are offense types where there's a lot of aggregated or litigated sentences or below or above, does that mean the commission should reconsider the OGS assignment for that? Maybe the starting point is not where it should be. And this is we did that a little bit, if you remember, thinking about the median sentences for the development of them. But it wasn't so helpful for the aggravated and mitigated. It was just like we had this dispersion, we took the median sentence. So now we'll have a lot better kind of insights into current practice to think about any refinements that the commission would want to make. And something we can run somewhat regular reports on, and we'll have that in the annual report, of course, but bring that to the commission if like, aggravated assault is, whatever it may be. So we're excited about that possibility, and the narrower ranges clearly give us that possibility to see, no, in fact, they're 2 levels down 75% of the time, or 2 OGS down, not levels.
There's no other thoughts or questions on conformity. We'll move on. I think about 15 minutes of your time left, and then we'll take a short break, 5-minute break to let us transition into the research folks talking about all the things that Matt said in the beginning. So for this, I wanted to mention before I get into the omnibus enhancement that as part of the supplemental materials provided to you, and it may be helpful in this discussion, the text of the guidelines is in your supplemental materials. And so it starts on page 67. For the omnibus discussion, you'll find the omnibus text of the guidelines on page 84 of the supplemental materials. I've also provided it on a slide if you don't want to look there, but in case you just want to read the guidelines while I'm talking, you've got them there. So with the 8th edition, just sort of talk broadly about some things for a moment. One of the areas in which we felt that the guidelines could benefit from was creating what is called the omnibus enhancement policy. For those of us that are used to the guidelines, we've long had an omnibus offense gravity score policy. And so these omnibus policies are like placeholders for when the commission doesn't have specific guidelines around. And what we wanted to do in the 8th edition was build this omnibus enhancement policy in to create that placeholder ability for when the commission is receiving mandates from the General Assembly to adopt a sentencing enhancement. And why is that important? If we think back to the 7th edition, which became effective December of 2012, and we go up until the end of 2023, the commission amended the 7th edition 6 times, and then also placed in there a supplement. So there were 7 modifications to the 7th edition over the course of a very short period of time. It pretty much became on a routine basis of every roughly 9 to 18 months, commission was rolling out an amendment. And there's some implications to that. One, it's a focus of commission time, both in terms of members and staff, to adopt that enhancement, go to the public policy process, submit it to the General Assembly. So a lot of our time spent, between 2012 and even 2020 was focused in on these amendments. And the amendments were really driven by mandates by the General Assembly to adopt enhancements. And so one of the areas in which we thought in terms of a policy, it would be really helpful to, one, be more responsive to the General Assembly when they mandate the commission to adopt an enhancement. As I noted in the past, the commission might receive that mandate and it may be 9 months to a year before the enhancement would take effect. So we certainly felt like that wasn't being very responsive. I mean, it was as responsive as we could be under that edition of the guidelines. So that was one of the primary goals. As I mentioned, having a placeholder in the text of the guidelines would guard against the need to continually amend the guidelines. And by continually amending the guidelines, it created complexities in just the application for practitioners. What addition / amendment am I looking at? And we didn't want to necessarily have to the commission to be forced to do that. And one of the things we also appreciated, and that certainly the General Assembly, I think it's proven this over time, is they've relied more on the commission to adopt enhancements in absence of creating mandatory minimums. So there's some utility in the guidelines and what the guidelines can provide to practitioners in the court for certain factors. So on the page that you see here is the text from the guidelines, section 303A.3 B4. And what the policy says, and I'll just read it, says the omnibus enhancement policy shall apply to a new sentencing enhancement enacted by the General Assembly and not otherwise provided in this section, 303 8.3 B4, or in 303A.12, which is the enhancement table within the text of the guidelines. So there's two places that you look into the text and you'll find information. One is in the text of the guidelines where we describe the enhancements. And then we included this table that shows you sort of the mechanics of the enhancement. So the intent of the policy is to say, when the commission is mandated to develop enhancement and we don't have an enhancement for it, this omnibus acts as a placeholder. And how does that omnibus work? So when we don't have an enhancement, what we would do in terms of the policy is look to the offense that's supposed to be enhanced. We would say, what's the base level OGS for that offense? And now we would increase it by 1 OGS. All right, so, you could look to deadly weapon enhancement. Possessed is +2, used is +3. This is a placeholder. So because these offenses could range anywhere on the matrix, +1 was what the commission felt at the time was an appropriate, it enhanced it, and relative to the level that it would enhance it in. It would have more meaning, certainly at the upper levels, in terms of state prison sentences, and it would have it like an appropriate relative meaning at those lower levels. We're not jumping too high. So what I want to say before I move on is the omnibus enhancement, as it acts as the placeholder, does not restrict the commission's authority at a later time to amend or revise the guidelines and adopt a more enhanced enhancement for that offense. Right? That just like the commission has an omnibus OGS policy where we have an OGS assigned to a new offense, at a later date, if the commission were to move in a direction of an amendment or a revision, you could review all of those things at once and decide, is +1 appropriate or should it be +2? Should it be +3? Right. So those are decisions that can be made in the future. But the fact that this policy is in place, what it helps is when that law becomes effective, that enhancement becomes effective on that date. We're not having this delay of 9 or more months until you actually can apply an enhancement. So here's what I'm looking for, at least in terms of discussion with the commission, is a bit of guidance on how to interpret this policy. And because we've received 2 mandates for sentencing enhancements since the 8th edition, one in 2025, one in 2024. And so I'm going to start with the most recent and talk through how we interpret this policy. I think this is straightforward. It gets to exactly what commission, I think, intended the omnibus to be for. And then we'll go to the act from last year. So Act 5 became effective August 26th of this year. It applies to the offense of corruption of minors. There's a course of conduct of a sexual nature. What the act says is that the commission shall provide for a sentencing enhancement when a person convicted of that offense is a mandated reporter. So the sentencing factor that triggers the enhancement is the status of that individual, the defendant that committed the crime, which is the mandated reporter. As we looked at that enhancement language, it says, it applies, the omnibus language, it applies when the commission doesn't have an enhancement and you increase the OGS by 1. So the commission does not have an enhancement. And we look at what the base level OGS is for that offense, be an OGS of 10. If the person's a mandated reporter, it would be an OGS of 11. And what's important for us from a staff perspective is Christy and her team have to program this into SGS Web. And we want to make sure that we get it in close to when it becomes effective because these offenses are certainly going to come through the system. And this is how we're programming this one. I think it's pretty straightforward. I don't, if there's any real discussion here, happy to have it, but this is like the poster enhancement language that we envisioned the omnibus to be. And this is not necessarily, this is where I'll explain what our thinking is and I'll walk you through it. And this is sort of where we'd like maybe a little bit of guidance from the commission so that we can program this appropriately. Act 18 of 2024 is the act that the General Assembly created, the prohibiting the use of the mobile device, right? Created this new offense, 3316.1. And if you recall, in previous years, the General Assembly had created a prohibition against texting at the time, which was 3316. Right, so they've expanded that to be hands-free in Pennsylvania now. So that's one thing that the act did, create that vehicle code violation. The other thing the act did was require the commission to enhance homicide and aggravated assault by vehicle when there's a violation of 3316.1. Right, so those are the two things in focus. I did a lot of other things. But those are the two things for us to think about at the moment. And just so you know, the reason we waited a little bit is there was a year-long implementation period to that act where you could only get warned if you were using your phone. But since June now, FYI, don't be texting and using your phone when you're driving home. They can cite you now for it. So here's where, we're just curious on the way to apply this, right? And so I'll start by saying that the policy says if we don't have an enhancement that we increase the OGS by 1, as we showed on Act 5. So what you're seeing here is this is the commission's offense listing snippet. So we're just focusing on homicide by vehicle. I'll mention this. Homicide and assault by vehicle, it doesn't matter which one I show you. All right, the operation of these things would be the same. So homicide by vehicle, base level offense, felony 3, offense gravity score of 2. So if it would be a really low recommendation if it was 2, thank you, 12. So the question is, if a person's violated 3316.1 and we look at the policy, I think you could say, well, the offense gravity score would be 13. I think that's certainly what we could say in a program into SGS Web. We just want to make sure we get this one right. And so this is where the guidance is. We currently, and have for a very long time, enhanced homicide by vehicle and aggravated assault by vehicle for all sorts of factors. Right? And what I'll say is, what you see here on the screen from the offense listing is that if you killed somebody while you were driving and it was because, and you also had a DUI conviction, we'd enhance that homicide by vehicle. Or if you were texting previously, right, we'd enhance that. If it was in a work zone, you didn't give enough space to a first responder. There's this constellation of situations in which we would enhance it. And then, maybe to further complicate this a little bit is, not only did we enhance it if one of those factors were present, but we said, well, what if there was more than one of those factors present? We'd enhance it further. Like you had a DUI and it was in a work zone, or you were texting and it was in a work zone, or you were texting and you didn't have a driver's license. There's all these sort of things. And so the takeaway from there is you've got your base level offense, and then you have a grouping of, if any one of those factors is present, you increase it. And then if you have more than one factor, we increase it. And this is where, we certainly can move forward, back up and say, we can move forward in programming SGS Web to say, if you have homicide by vehicle, and now you also have a violation of 3316.1, the OGS will be not 12, but 13, right? I guess the question is, do we have an existing enhancement for homicide and aggravated assault by vehicle? And if we do, it would require us to slide that offense into existing categories and subcategorization in a published offense listing. You know, I'm not putting my thumb on either one of them. I think we can see it in either direction. I'll say this, and I think it'd be okay if you did just +1, right? And we can see, you know, someone appeals it, what the appellate court might say, but I just wanted to raise it because, of course, right out of the gate, we were really excited about this policy. The General Assembly, thank you, gave us a complicated one to deal with. Or maybe we're just overthinking, but so here, this is where we are. It's not asking for a vote on anything. It's just to put this on the table with the commission for some discussion and guidance. And, you know, happy to take any questions if I wasn't clear, at least in my description of it.
I've switched back and forth every time I think about it. So, we've had that discussion before. I still, today, I think I'm thinking differently than when we had our discussion, so I don't.
This isn't the reason for doing it, but I think in terms of programming, I think it'd be probably easiest, and that, again, not a reason to do, but it'd probably be easiest to just +1.
Yeah.
And it's also, that's the new policy, and should we read more into it? Not so sure. And the thing would be, in terms of being responsive to the General Assembly, there is an increase from the base level offense, right? And courts still can aggravate and mitigate or aggravate from that if they wanted to in terms of the recommendation. So I think we can move in that direction, and that's at least in terms of sort of setting a precedent when we're seeing these new enhancements coming in. That's consistency for practitioners. Just add one to it. And then look, we can table just the omnibus enhancement policy in terms of whenever the commission decides to look at the 8th edition. If we hit a threshold in which the commission feels this is a good time to review it and maybe revise it, you know, I think we will learn much in the coming year or more on areas for clarification and providing context. So,
Right, on this one, so the conviction for 3316 has changed. Still 3316, it's just there's a change in the statute of 3316.
there's a new statute, 3316.1. So it's about as close as a change in the existing one, but a new statute.
But it is a new statute.
And there's no scenario where you would somehow like double count where the omnibus enhancement would bump it by 1, and then the courts would also, for some reason, decide to use one of those existing enhancement categories?
Well, I think the answer to that is not double counting, right? If you can only use the factor once, but let's say there's also some other sentence enhancement that can apply. One that I always use, and I don't know that this happens very often, but you think about a DUI. And this happened, I always use this example, rural Pennsylvania in hunting season. It's a pretty common practice that you have a hunting rifle in the back of your truck. And if you're driving and you get pulled over while you're drunk and you get a DUI, you also possess a deadly weapon during the commission of that crime. So you could see scenarios, making one up in my head, where you've killed somebody driving drunk, so you have a DUI conviction. Then you have a rifle in the car and it's possession of a deadly weapon. So both things could apply, right?
You know, the minors enhancement too.
Right, yeah. And so multiple enhancements can apply, but we wouldn't be counting, we wouldn't use one factor to be adding to that.
Right, yeah, which I mean, and those other ones already are kind of staggered, right?
Yeah.
There's more and more.
And that was, yeah, it's a busy one, to say the least, but that was to try to have a recognition that it's bad if you had a homicide by vehicle and you had one of these, and it's probably worse if you had all of these things going on. That was sort of the fundamental idea behind that. And then there was, because it's on the screen, I might as well say it, then there was, well, what are those violations? And it really became down to like behavioral versus administrative, where you should have had a license, or your license was suspended, or you're texting, right? That's more of a behavior. So those were what the commission at the time, and there's this whole evolution of these two offenses, both homicide and aggravated assault, and the building out, because the General Assembly over time continues to give the commission new factors to consider, so. Okay, I think we will take a quick 5-minute break, come back at 10:25, if that's okay with the chair. Great. Thank you.
We will continue on, and I think we're gonna turn it over to.
All right, thank you. So the second half is going to focus on, of the policy meeting, will focus on the research initiatives that have been underway at the commission. And we may run over slightly to 11:10, at which point we'll just transition right into the business meeting. But hopefully we'll be able to go through this a little quick, but give it enough time to illustrate and showcase what we've been working on. As most of you know, our big initiative for the last year and a half in the research area has been in response to SR 196, which asked us to look at a comprehensive examination of veterans involved in the criminal justice system, especially with associated mental health issues associated with their service. And just want to say a little bit about the report, and then I'll turn it over to Noah. First and foremost is that this was a tremendous effort by the commission. So to accomplish these types of resolutions, I would say we had 1.5 full-time equivalent staff every day working on this for the last year and a half. So when we have, and we'll hear later, instead of 22 FTE, only 18 FTE on staff, that's a sizable portion every day, not just on average. So to do that, and we'll highlight something we'll talk about later too, is we really leverage our research partnerships. So we've had grad students working on this, we had postdocs working on this, and they really supplemented the efforts of the commission. So that valuable relationship with Penn State and having those bright young folks who are really productive certainly helped that. And I also want to just start by thanking Representative Bonner, who chaired our advisory committee, and then all the partners across the state. We had even though it was originally a 6-month timeline, extended to 15 months, it was a really aggressive timeline to accomplish all the work we did. So a great appreciation for our partners, folks like the DOC, the DMVA, the courts, and others who provided us access to data on really short notice, as well as access through site visits and surveys and communication and interviews with key stakeholders. And also really quick review of targeted sections of the report. Noah will talk a little bit about how we went about disseminating sections of the report rather than the full report for stakeholders who were experts on, let's say, problem-solving courts or treatment courts, veterans treatment courts, et cetera, to review just those sections of the report. And this is, maybe here for me to say as part of the team working on this in 25 years of working in this space, this is one of the best reports projects I've ever been involved with. So even though it's externally imposed on us, I hope when you review the report, you'll see the incredibly high quality of research and information. And I hope that it really impacts the Commonwealth and other jurisdictions and states are considering responses to veterans involved in the criminal justice system. So I'll just note one other thing, and then I'll turn it to Noah. We'll be posting the final report on the website today or tomorrow, as well as, hopefully you noticed, we send you a standalone executive summary. The report is about 175 pages. So we have a 8-10 page executive summary that really distills this. And we also will work with the Senate and also folks maybe in the House about the opportunity to present to the judiciary committees whenever they would like us to come and speak with them. So with that, I'll turn it to Noah.
Thank you, Matt. I'm going to keep this relatively brief as we've talked about a number of these components of the study in prior meetings. So I'm going to get right to the core of it. First, we want to point out that to guide this research inquiry, we impaneled an advisory board committee who helped guide the study, give us feedback on our research questions and our research methods. And several of the advisory board committee members read targeted sections of the report. We also had other partners who would send out targeted sections of the report for review, and we'd like to thank them. And these are some of the partners. They provided various support, including linkage to research participants, feedback on sections of the report, access to research sites. It includes the site visit partners who visit Allegheny, Chester, and Jefferson counties, and the Regional Veterans Treatment Board, the Department of Corrections. We went to SCI Houtzdale and saw their veteran service unit. We met with several individuals from the Department of Military and Veterans Affairs and had support from AOPC and the Pennsylvania State Police. As Matt alluded to, this was a mixed method study with several core components. The core of the study was a multi-stage process of acquiring a veterans identifier from the Department of Defense and merging that veterans identifier with a variety of administrative criminal justice data throughout the Commonwealth to help give us insights into patterns of veterans' involvement in the criminal justice system. This is the most expansive study of veterans in the criminal justice system ever conducted. Most research on veterans has been confined to either jail or incarcerated populations. Ours looks at prevalence of criminal justice involvement among veterans from filing on throughout the criminal justice system. We have an extensive review of criminal justice policies in the Commonwealth and throughout the nation related to veterans in the criminal justice system, surveys of county jail wardens and president judges, and thanks to all president judges and county jail wardens for completing the survey, site visits, as I mentioned, and then interviews, probably over 50 interviews with various criminal justice stakeholders and individuals who assist veterans involved in the criminal justice system. I want to focus here a bit on recommendations, and our first one is that veterans should be identified in the criminal justice process as early as possible. Actually, let me take a step back. One thing is our recommendations are guided by 3 frameworks that we adopted during the course of the study, and they're largely public health frameworks. The first one is the Veteran Sequential Intercept Model, which argues that veterans, as early as possible, should be linked to treatment resources within the criminal justice system, or when appropriate, should be redirected from the criminal justice system. The Cascade of Care, which argues that it is best to identify veterans as early as possible in the criminal justice process, screen them for behavioral health issues such as post-traumatic stress disorder. If needed, link them to a further assessment and then to treatment and continuing care. And then a third one we haven't talked about in prior commission meetings is something called the Whole Health Framework, which is an initiative by the Veterans Health Administration to take a more holistic approach to health, which addresses not only specific symptoms that an individual may have, but other aspects of their life, education, employment, relationships, to try to encourage them to be more healthy. So those 3 frameworks guide our recommendations. And our primary first recommendation is that veterans should be identified as early as possible. And key to this is having standardized definitions of veterans. The definition of veterans varies widely across local, state, and various agencies and at the federal level. And that impedes the identification process. Also, when possible, an independent records-based system such as Veterans Reentry Search Services or SQUARES should be used to help identify veterans. Typically, veterans identification is done through self-report process, asking individual about their veteran status, and that has several weaknesses that can lead to an undercount of veterans. So an independent process is the best, and as early as possible is the best. And once that identification has been made, it's essential that that identifier travels with the individual throughout the criminal justice system, from filing all the way, if necessary, to state incarceration. We also argue that additional data on veterans and their needs should be collected and shared across decision makers within the criminal justice system. This includes the traditional outcomes that we collect, such as recidivism, but also we really need to collect data on the veterans' cascade of care. What percentage of veterans that are identified in our system are being properly screened for behavioral health conditions, are receiving treatment? This process helps identify needs, unmet needs, that will allow us to address those needs. And then it's important to measure social determinants of health among these populations. What percentage of these groups have housing needs, their employment status, and then these data can be used to identify unmet health needs and to make more holistic assessments of existing programs. And then third, we argue that formal evaluations of veteran-specific programs should be conducted along a number of dimensions. Some of the programs that we argue should be evaluated thoroughly include veteran service units, including ones that are run by the DOC. There's also one in Allegheny County's jail and veterans treatment courts. Now, these evaluations should include fidelity to best known practices. There are some best known practices for addressing veterans' needs in veterans treatment courts as specified by All Rise. And to the extent to which a program follows those best practices, the program and the veterans within that program are more likely to be successful. So we really need to study whether our veterans treatment courts are implementing veterans treatment protocols, best practices. Outcomes, there needs to be an outcome evaluation of a variety of outcomes, including recidivism, social determinants of health. So for instance, is veterans engaging with the veterans treatment for helping the veteran gain employment or prolonged employment? Is it helping them gain more stable housing? Those types of analysis need to be done. And then cost effectiveness. Are these programs cost effective, reducing costs and along a variety of domains, reducing costs associated with recidivism, reducing costs associated with incarceration, etc. And then fourth, training and education on issues associated with veterans involved in the criminal justice system should be expanded or developed. A key part of this is making criminal justice stakeholders aware of the available resources. It's a very complex array of resources throughout the Commonwealth. There's resources at the local, county, state, and federal level, and they're hard to navigate. And a first step would be to make people aware of the available resources and of the linkage facilitators, individuals such as regional program outreach coordinators for the DMVA, the VJO, Veterans Justice Outreach Officer. These are individuals who can help link the justice involved veteran to the resources that are available in the community. It would also be beneficial to have some cultural sensitivity training about how to best interact with veterans in the criminal justice system. There's a lot of stigma associated with being a veteran in the criminal justice system, and addressing that stigma would better help their treatment outcomes along the cascade of care. Last, the current study should be expanded to focus on earlier steps of the veteran sequential intercept model. We primarily focus on from court filing on to up to and including state incarceration. It would be very worthwhile to look at earlier points of contact with veterans in the criminal justice system, such as emergency services and or the police. There's been an increase in deflection programs that deflect individuals from arrest. I believe there's one in Montgomery County, and it would be good to evaluate the efficacy of those programs along these dimensions that I highlighted in point 2. Last, it's important for us to, not for us, but for someone to study reentry among veterans. Our project didn't really go that deeply into reentry processes. It would be useful to study those processes and to get recommendations on reentry from jail and from prison, and also from veterans treatment court. A big argument is that there needs to be continuity of care after they exit the program. So those are the main recommendations. And our next steps are to focus on disseminating some of the products, some of the findings and ideas from our study. It's important to disseminate our study's findings because that can help impact practices throughout the Commonwealth. It can help lead to new innovations and new ideas. And some of our modes of dissemination we presented on SR 196 at the National Association of Sentencing Commissions Conference. We have our postdoctoral fellow, Nicholas Goldrosen, who is presenting on Senate Resolution 196 at a symposium in New York that is for criminal justice practitioners. We're going to do some data snapshots on SR 196 and a variety of other modalities. So thank you. We appreciate it.
Right. Thanks, Noah. And I think even just from that brief presentation, you can see how complex this landscape is. One of the things that we found in our work is, and Noah alluded to this, of how many actors are involved locally, county-based, state-based, federally based, and how individual jurisdictions can really leverage those resources for veterans is really important. So that means making people aware of that. But as Noah said, identifying that individual that they are a veteran early in the system, screening them, assessing them for their needs, and then sharing that information as that individual moves through the system. So if the police determine that's a veteran, the court should know that they're a veteran. If the magisterial district court judge knows they're a veteran, the Court of Common Pleas judge should know they're a veteran. That information should then go to the jails, et cetera. And currently that is not being shared systematically in jurisdictions, and that's a limitation. So I think that our report really addresses ways to be thinking about that, as Noah alluded to, this cascade of care. And the beauty of that, and then I'll move on to the next section, is that model works with an attrition-based thing. And if you go back to the beginning a couple months ago, only 5% of individuals in the criminal justice system are veterans from our data. So the burden on courts could be 1 or 2 individuals a day that they have to identify, screen them. Not everybody then needs a clinical assessment. It's some proportion that have the screening says you need an assessment. And then not everyone who's assessed needs treatment. So we're winnowing down from 5% quickly to a very small population that targeted interventions could pay great dividends for them. So with that short summary, open it to questions.
Yeah, I guess the challenge is who's charged with making that identification initially? I'm just thinking, as you were speaking, maybe perhaps the pretrial folks could ask that question.
Yeah, that's going to vary county to county though,
Yeah.
whether there's a, active pretrial program. I don't know, in booking,
Yeah.
that's, I think where you can try and get that information. But again, I think, and we had this problem with our veterans court, I don't know if you did, what is it someone that's honorably discharged? Is it someone, that was in for 2 days? What do you call a veteran? And again, it's going to be self-reported for the most parts. But I think for my quick read of what we saw here in the Senate resolution or the Senate report, I think there's some good ideas there, but I think the identification is key. I don't know, Judge Daly, sometimes defense attorneys are going to highlight, someone's a veteran in front of me because, it's a good thing to do in front of the courts, so that happens. But sometimes it doesn't happen. It's not asked and not brought to my attention. Sometimes you stumble upon it.
Right.
And then, the good thing about the defense is we do have our federal counterparts with the VAs and the things of that nature to provide a whole host of treatment opportunities that we don't have for everybody else.
I think, Judge, the booking would probably be the best. That way you're catching it as early on as possible. We know at the prelim, if we're trying to negotiate a plea, now maybe Veterans Court is a good option for this person. And there's a lot of defendants that won't see, may not see pretrial services, right?
Right.
So,
Yeah.
So I think that's probably the best spot if we can do it.
It seems like booking has to be the place where
Yeah.
I get it.
Yeah, we haven't formally explored. It was kind of outside our purview here, but our thinking is if the court were to generate a list of the individuals with the filing at the time that the charges are brought, this database can be used and the names can be run across that. So we know that self-reporting, there's underreporting because of the things that Noah mentioned about stigma. So this would be a mechanized way that is a formal definition, and that's put into some electronic system that follows that individual through from pretrial detention to the jail to, et cetera, et cetera, et cetera. So that's a service that is available. And again, how that would be implemented in local courts, I'm not positive, but.
And I guess for DOC and parole, do you guys we identify people when they come in, or how does that work?
And we're still doing our double checks on them too when they come in. I mean, we run everybody through and ask them as soon as they come through classification.
Okay.
And the DOC is using, currently was using something called VRSS, now is using Squares, which is just another federal database to confirm veteran status.
Okay. So it's not-
Yeah, we've been struggling. I mean, that was always a struggle, and I think you guys have really done some remarkable work in connecting the two, cross-pollinate the two systems to really get us a good idea what the numbers are. That was remarkable because we've wanted that data forever. And we definitely deal with that at intake, especially because resources for reentry. And we want to know if somebody's a veteran because, but there is some questions about the definition of what a veteran is and whether or not they'd be eligible for resources. So it's definitely a challenge, but I gotta commend you. It was remarkable what you were able to do with this study and get this data so that we actually have a good idea of what that number is, what we're working with, because we self-report, as you knew, wasn't kind of doing it for us.
Thank you, and I should point out, Brett Miller and Jordan Zavankovich led that effort, and also in combination with Christie and the IT team, so big team effort.
Continue. And no, kudos to the Senate for passing the resolution, which first came through. We weren't crazy about the amount of work we create, but ultimately a great idea, and then great work here, getting it done. So.
Matt, if I could just add one thing, the framing that, first of all, congratulations. This is a remarkable report, and there are lessons in those 5 points for every problem-solving court, every effort for safe diversion that we can imagine, for the intellectually disabled, for mentally ill, for just go up and down the line. I think, with your permission, I think this should be shared with every criminal justice advisory board in every county throughout the Commonwealth as a framing. I mean, with veterans, I know here in Allegheny County, and Joe knows this. I mean, we're one of the earliest counties to deal with veterans in this space. But I can see so many lessons for other people, and I just love the framing of this. And if you think it's appropriate after the Senate has this formally, I think sharing this with our CJABs across the Commonwealth would make a great deal of sense. But congratulations, this is a remarkable report in the 15 months that you have. And, when we first got the resolution, we think, how the hell, with time and everything. Meanwhile, what a gift. It's a great resolution. Thank you, guys.
Just one quick, and actually, I'll echo what everyone else has said. Given where this started, it's a very impressive achievement, and I'm grateful for having these takeaways. I'm curious about, given, this being a unique comprehensive study of a particular kind of, class or identity within the system, has this process spurred any ideas for, and Professor Rega, I think, already listed a couple other potential categories, but has it spurred any ideas or thoughts about other categories of folks who enter the system that may be worth another report of this nature? Not saying it'll be me, but if there might be some thoughts about other places for study.
Not that we want to add to your workload, but I think the representative is right. I think there's that framing. It'll speak to a lot of folks across the Commonwealth, the framing, those 5 points.
Yeah, and I'll just add one piece that's embedded in our report and not necessarily highlighted in these recommendations. Of course, veterans also struggle with substance involvement issues. So I think individuals with substance involvement and mental health, not just for veterans, would be two natural extensions of this model and this approach, linking them, of course, to treatment, screening them, assessing them, finding the appropriate needs early in the process. When is that done? So I think those would be two that are natural dovetails that we've talked about. Our resolution here was mainly on the mental health components, not so much on the substance involvement.
Right.
Even we talk about the comorbidity of these multiple conditions for these individuals. Okay, so we'll move on, and our team will be brief here. To the next module will be on our ongoing efforts for short sentence parole. Our sort of second and a half evaluation, if you would. We've done a continuing stream of these, and these are defined for us in statute to conduct these evaluations. But I'll just say quickly, it's great to continue to partner with DOC on these type of efforts and be involved in these evaluations. And so with that, I'll turn it to Brett.
Slide on here, just next one. Okay. All right, so we have two topics left to discuss here. So because we've hit short sentence parole a lot over the last couple of years, as Matt just said, I think maybe what I'll do is kind of speed through the short sentence parole part of this, and then we'll get to the risk revalidation, which I think is a little more important maybe, and we haven't talked about as much, so I'll make sure we get some time to focus on that discussion. So just briefly, the short sentence parole program is a DOC program. It was established in 2020. And basically the idea of the program is to identify the lowest risk individuals going into state custody, those with short sentences, less than 2 years, no violent offenses, no sex offenses, basically using these criteria to kind of cordon off the least risky state inmates. And then as long as they don't suffer any serious misconducts, allow those individuals to be released directly at their minimum date without going through the traditional parole process. So I kind of talked about eligibility. So I'll just go really quickly through kind of how this works. So for a standard state inmate, they go through the intake and classification process sometime around 3 to 6 months before their minimum. DOC puts together the package for parole that gets handed over to the board. They conduct an interview at the minimum date. And then for a nonviolent offender, which is kind of who we're talking about here, there's somewhere around a 50% chance that they would be released at that first interview at their minimum. If they're not released at that interview, they would then have to wait another year, go through the same process again, and then on and on until they eventually max out. So what we found for short sentence parole, the median sentence is 12 to 36 months. So someone could potentially spend an extra 2 years in incarceration going through the standard parole process versus the short sentence parole process. Another difference in short sentence parole is DOC actually prepares this somewhat reduced parole package for the board a little bit earlier in the process, like 8 months before the minimum. This gives the board time to review that package, and then DOC conducts a review on their end to see have there been any serious misconducts. If not, then if it's a successful review, they're released right at their minimum date. So as we mentioned, we just did an evaluation of SSP in 2023. There were some challenges with evaluating it so early, especially since the program was implemented during COVID. But we did have some findings that were generally very positive, I would say, for the program. Number one is that this early release mechanism led to a reduction of more than 60,000 bed days per year. Just that savings alone added up to 2.75 million in savings annually for DOC. And that's not even taking into account reduced administrative efforts by the parole board and by DOC. Another interesting finding was that it seemed that SSP participants seemed to have some kind of a motivating factor, knowing that they had this possibility of early release. So they conducted far fewer misconducts than the general population of DOC, and especially far fewer serious misconducts. And then finally, we found that SSP participants had a very low recidivism rates. We weren't able to conduct a full 3-year follow-up period for that study because the program was so new. But the early results suggested that recidivism was much, much lower than the general DOC population and about the same as other DOC inmates with similar short sentences. So our goal as we do this second evaluation is kind of to revisit some of those findings that we found early on. Now that we're 5 years into the program, let's see if some of those findings are holding up. And just looking at the utilization of the program, starting in 2020 during COVID, you can see there's kind of a slow buildup for the program, but starting around 22, looking at more than 500 inmates a year that have an opportunity for this early release. Another big finding last time around was that for whatever reason, there seemed to be a higher representation of inmates from more rural counties that were involved in this program. So 4th through 8th class counties, those individuals made up about a third of the overall DOC population, but they make up almost 2/3 of the SSP population. And then looking at our top 2 counties, they make up about 20% of the overall DOC population, but only about 5% of SSP. So we don't know exactly what's causing that, but one theory is that maybe just different judicial discretion happening urban versus rural. Maybe in the urban areas they have more treatment options or local options rather than using state incarceration. And then again, demographics, we're seeing some of the same trends we saw in 2023. The program is predominantly male, but less so than the general DOC population. Program is individuals are more likely to be white, and they're more likely to be older. About 2/3 of the population is 35 and above, as compared to only about a third of the DOC population that would be 35 and above. And so I mentioned one option of the urban areas might be just the choice to use local treatment programs. Some of the lead offenses for individuals in SSP did commit substance involved offenses. So PWIDs, DUIs, just those 2 offense types alone add up to more than half of participation. And then you add in theft, and those 3 offenses make up 3/4 of SSP participants. And again, we mentioned the finding of misconducts last time around. SSP participants, knowing they had this early release option, committed far fewer misconducts. That continues to hold true now 2 years later, where compared to the DOC general population, SSP participants are committing about 9 times fewer misconducts and about 20 times fewer serious misconducts. And we added in a middle comparison group here, which is other DOC inmates that weren't in the program, but also had short sentences and got released at their minimum dates. So those individuals also do well in terms of misconducts, but still not quite as well as being involved in SSP. So we're still conducting this evaluation. Some of our next steps include finalizing a recidivism analysis. So I can tell you we are partially through that analysis, and it looks like those 3-year reconviction rates for SSP individuals again are looking very low. So about half of the general DOC population. Another area that we didn't get to take a very good look at last time was programming in DOC. We didn't have the best information available to us last time. This time DOC has shared extra programming information, including prescribed programs and a little more detail on what that programming entails. So we're hoping to flesh that part of the report out a little bit more this time. And also include a cost benefit analysis and then any recommendations for the program. So I know that was pretty quick, but any questions or anything on short sentence parole?
One question I had, Brett, is on the slide of the different categories of offenses. I was surprised that DUI was 25%. That seems high. Am I wrong, or like a?
So one of the things about the individuals that kind of end up in this program, generally the the lead offenses aren't necessarily the most serious, like relative to state sentences, but they have higher prior record scores. So this might be a third DUI or a fourth DUI.
I see, okay. That's why it's probably clarification. Thank you.
All right, so if there are no further questions, I think we can move on to our discussion of risk.
So I think what we're gonna do is include the policy meeting and then include the final presentation that we were gonna